An asbestos contamination scare is rocking New Zealand's schools and preschools. Hundreds of them have contacted the Ministry of Education. Parents want answers. Schools also want to know whether children have been exposed to risk. To help us understand the legal implications, we're joined by Merlyn Remiens, solicitor at John Miller Law in Wellington. Merlyn, nice to have you on the program. Good morning.
Good morning. Happy to be here.
So what is the legal situation? I mean, if your kid eats asbestos from some coloured sand, can you sue the company?
No, you can't sue the company. So when you're contemplating any legal action for personal injury in New Zealand, the first question you need to answer is, who am I bringing this claim against? And the second question is, what am I getting out of it? So we're quite lucky in New Zealand insofar that our personal injury jurisdiction is governed by ACC, meaning that the only question is, has an injury been incurred? And if the answer is yes, then if it falls under the broad umbrella of being incurred in an accident, you are entitled to claim entitlements, which essentially serve as a replacement for what you might otherwise claim in a civil suit. So it's more accurate to say that you might have a claim with ACC, and you are, in fact, barred explicitly from making a claim against the manufacturer or distributor.
Right, okay, so actually legally there's not much we need to be aware of here.
No. If you suffer an injury, which of course would be the worst outcome, and as I understand it, relatively unlikely to happen, then you are automatically entitled to, barring a few very unlikely cases, the kind of entitlements that you might otherwise claim if you were to bring such a suit.
Is it strictly and completely illegal to sue if you're covered by ACC for something? Is there any way or avenue where you can sue in New Zealand?
Yes, but only in very limited circumstances. So the bar is considered absolute. It's binary. Either you do have cover under the accident compensation scheme or you don't. And if you don't, it's unlikely that you will have suffered the kind of harm which would otherwise bring a civil remedy. Now, for claims sitting outside that bar, you're claiming a different kind of remedy. So what you get for ACC is remedial compensation. You will be returned to the best of the corporation's medical ability to the state you were prior to incurring that injury. Now, the other kind of damages that you can claim in a suit might be punitive, but the Supreme Court in 2010 determined that crossing this bar and attempting to claim punitive damages requires a standard of negligence that's essentially or so close to as to be indistinguishable from intent to cause harm, which, what I understand of the facts as they presently exist, is not the case with this asbestos exposure.
Ah, okay. Merlyn, what about, so Chinese company manufactures something, sends it here, we buy it, it harms us. Can we go after multinational companies, even though we're covered by ACC here in New Zealand, can we go after these big companies overseas?
An individual? No. Because, again, the bar applies. If you have suffered harm, which might give rise to a reasonable claim, then ACC would give you the compensation that you might otherwise get, and you are barred. Now,
yeah, but can't I sue them?
Say ACC.
Can't I sue them in another jurisdiction? Like Merlyn, nothing to do with New Zealand. Can I not go to America, hire an American lawyer, and sue the crap out of them?
Arguably, yes, but your remedy might not exist and therefore the suit would be purposeless. So if you are claiming against a Chinese corporation using an American lawyer for harm incurred in New Zealand, you would have so many legal loopholes to jump through that it may well be purposeless. Not saying that it's impossible, but on the facts as I understand them, it would not give access to a remedy.